Life, Loss and Legacy is a general information podcast only. This does not constitute professional advice as we simply don't know your individual circumstances. If you do have any questions, please be sure to contact the guests of the episode. It should also be noted that the opinions expressed by the guests and host of the podcast are theirs alone and do not represent the opinions or perspectives of their employer or any other associations. That's enough warnings. Let's get started. Hello and welcome back to Life, Loss and Legacy, a planning solo podcast for people in those first few years after losing their partner. My name's Jordan Vaka. I'm an independent financial advisor with Planning Solo, and I'm very excited to be joined today by Zinta Harris from Resolve Estate Law. G'day, Zinta. How are you going?
Hi, Jordan. Thank you so much for having me.
Not at all. Not at all. And one of the reasons I'm excited is we're talking about collaborative practice, which we're both really passionate about. But a very quick intro about Zinta. Zinta is from Resolve Estate Law in Queensland, with over 25 years experience in wills and estate law. She's one of the leading lights in collaborative practice and confesses to be a recovering litigator, but now an avowed and firm resolutionist. So I'm very excited to talk about exploring some of the other options, because I think people have a very fixed idea sometimes around how to resolve disputes when it comes to estates. So I'm looking forward to hopping into that. Now, Zinta, anything in particular you want people to know before we get started?
Oh my gosh. What would I like people to know? I would like people to know that there is a very different way of resolving estate disputes that doesn't necessarily involve the traditional legal court pathways. And I think this is the reason why we're talking about collaborative practice today on this podcast. It's not a very well-known concept in the wills and estates world. It's been far more utilised by the family law scenario in the divorcing context. But I just want people to get the message that just because you speak to a lawyer first and they tell you what the process is going to be down the traditional pathway, you can always ask whether there's something else that can be done sooner by way of, even if it's an earlier mediation of some sort before you start the court process. Instead of starting the court process, I should probably more particularly say, because that's really the point of collaborative, is to keep people out of court and to allow you to stay in control as the person actually facing the conflict of your own settlement. And that's the big take home that I would like people to really understand, that's the big difference in the process.
And I think that can be, we'll hop into the specifics, but that can be a really big idea of staying in control of the process. Like you say, we do quite a lot of this on the family law side, but it is almost, you're always challenging that default assumption that I must go to court, it must be that way, because that's how it's always talked about. But that's really why I wanted to record this episode, is to explore that there are different ways for different families to resolve different disputes that don't end up in everybody spending huge amounts of legal fees and time and energy in the court process. So we will be covering three broad areas during our discussion. The first one is really, what is an estate dispute? You know, we talk about it as if it's really clear, but it's a broad area to cover there. And then what's the collaborative approach to resolving them, and how does that differ from kind of, let's call it the default method? And then also, when is a collaborative approach a really, really great idea? Because I have to confess, I'm not super familiar with it on the estate side, but I know on the family law side, it's not for everybody, but the people it is for, it's really for.
Yeah.
So I'd be keen to see if that's the same case on the estate side.
Same, but a little bit different.
Excellent. That's cool, because, I have lots and lots of questions. So hopefully we won't be here for weeks and weeks talking about it. But we'll hop straight into it. We'll hop straight into that first topic. Can you talk us through a little bit, is there a legal definition of an estate dispute, or is it more kind of a shorthand for a variety of things that can happen?
It's definitely a shorthand for a variety of things. So I guess the most typical estate dispute that people know most about, I think lay people know most about, is what we call the family provision application, which is essentially where someone has either been left out of a will altogether, or what they've been given under a will is not sufficient. So they're making a claim against the will for something or something more. So that's a typical understanding. The other one that's probably also reasonably well known is the challenge to the will itself, when people are concerned about the person's testamentary capacity to have made a will, or someone's undue influence of the testator in their later years in life, where wills that have been made in a certain way for a long time then suddenly change, in later on in life. So they can be sort of what we call suspicious circumstances and challenging the actual validity of the last will. And then the other big area that we're seeing becoming, and it's not typically an estates dispute because superannuation isn't always a part of the estate, but because our wealth these days is so often held in self-managed super funds or even in ordinary industry funds, where often there's large sums of life insurance attached, it can be a significant asset in itself. And so we're seeing now definitely a move in towards that estate, the superannuation disputes area, because people see it as all part of something that happens when someone dies. They're the big areas, but then the other thing that happens is people take a bit of a scattergun approach, and sort of there's a bit of everything in all of the matters. And the other thing that happens is sometimes people take a little look back and say, who were the attorneys, who were looking after the affairs of the deceased before they died, particularly if there's questions over undue influence. And then sometimes the need to look back and get attorneys' accounting to be done in a historical way to find out what on earth happened to the estate before death is another part of all of this stuff. So it's kind of
it's
a lot
it's
of
it's
things.
a, it's a,
Yeah.
a broad range, and I mean, talking to other lawyers and talking to other people, it seems like often when you meet with a lawyer, you say, "Look, I'm really unhappy with the way this is played out. I had concerns maybe around mum's capacity, or my husband's this or that." The lawyer will then look at the whole picture and say, "Okay, well, your best case or your best outcome is likely to be pursuing the construction of the will or talking about a family provision claim or things like that." But taking a step back from that, I guess, what are some of the triggers that you've seen that ultimately makes somebody say, "I'm unhappy with this. I want to have a chat with a lawyer about what to do"?
Well, I think often it comes down to people's expectations and those expectations not being met. So, or simply a sense of entitlement or genuine concern that their deceased loved ones' wishes, true wishes, aren't being reflected in the last will. And then, of course, we have the situation where some people just don't do wills at all. And so they're left on an intestacy where, each state has a different set of rules and how they apply. And then they say, well, that definitely wouldn't have been what they wanted because they've never spoken to their, brothers and sisters or whatever else it may be if it's down the line, they would have preferred it to go to the people that were looking after them, etc. So there's all of that. I think a lot of it comes down to that sort of misunderstanding or an expectation or a thinking that I've got a better understanding of what it is, or simply it's just not fair. It's not fair that I get nothing and everyone else gets much more. There's that. But sometimes, can I also say, it's genuine need. A lot of times will makers, and I'll say will makers, testators, when people make wills before they die, they think they want to do the fair thing and they leave everything equally when their children's needs are quite disparate. And you may very well have people who have, disabilities themselves that need extra support, and there might be other reasons why, there might have been more assistance to people, some children earlier in the piece and less to younger ones or whatever it might be. So sometimes this equal is fair is not a great solution actually, because it doesn't always fit the family to to make it fair ultimately.
It's We had some friends down for the weekend, and we actually had a conversation where we were talking about estates and things because that's the kind of high velocity life I lead. Over dinner, we were talking about estates, and it's really, really rocking along. But one of them was observing that in their family, I think there's 4 siblings. One of the siblings will receive a much larger bequest from their father. The father has been very clear about this, and the argument seemed to be because they would need it more. Everybody else is more established, higher income, all of that. And the consensus around the table was that was a really unacceptable outcome. Like, that didn't feel fair. And I was talking to another lawyer, I think it was Lucy Percy, a little while ago. She said that kind of approach of catering for different need can also play into like a lame duck scenario where the lame duck is the one that gets the greatest benefit out of the estate, which doesn't feel fair, and it rolls on and on and on. Um, so I guess for the people that we're talking to, most people, they will have lost their partner, their husband or their wife, and now they're trying to work through what to navigate. In a scenario like that, have you seen adult kids bring a claim against the estate or a dispute against things?
Absolutely. Look, in this current scenario where we've got a large transfer of wealth that's happening, like it's the biggest, it's just starting to happen. We've got lots of adult children who are struggling financially, who have also overcommitted themselves in terms of lots of different ways. Different generations live very differently, and so there's financial strain. And yeah, there are lots of adult children claims. We're seeing them anyway. We're either defending them when we act for executors, or helping adult children make those claims in circumstances where they feel like everything's been left to the second spouse, and they'll never see it because that spouse will probably outlive them, or vice versa. It's something like that. So yeah, we do see that. But that said, adult children, there's a different standard that most of the courts across Australia apply in those situations. It's not simply an understanding of I'm entitled because I'm a child. The court requires adult children to show that they have a special need and to be able to establish something. So just because you happen to be biologically connected to the deceased doesn't necessarily mean that you're entitled to whatever share you think it might be. It's sometimes quite a nominal amount, particularly when you've got to balance the needs of the spouse. And that's always the thing. There's competing claims in these sorts of matters. So and a spouse, particularly of a longer relationship, will be entitled to more because there's a need to care, particularly if that spouse has been significantly financially dependent on the deceased. And whereas adult children, you would imagine, are actually out of the nest, so to speak, and living their own independent lives and have the rest of their lives ahead of them to make of themselves what they will.
And I think sometimes about the pressure that, let's say, for a traditional scenario, husband passes away, wife is left as the executor. Maybe there's 3 kids, one of which is estranged. They're now in the middle there because they're acting as the executor in the interests of the deceased, but also defending their own interests as the beneficiary of the will potentially against their own children. That must be an emotional just cauldron of entanglement and mess.
It is probably quite messy for all of those reasons. Yeah, and you've got people wearing different hats. So someone might be asked to be an executor, and the law recognises that if someone's written their name in the will, even if there might be some kind of conflict of interest, you know what I mean? It's that sort of overlooked because the person making the will can choose who they want to be running it. But again, the other scenario we see is where they, again, want to be fair and put in all of the children or the spouse and the children, so that the children keep the spouse in check or vice versa. And it's just a nightmare, and no one can agree, and then it's really difficult. And so sometimes, we've got to get those things sorted out, and you have an independent executor appointed or something like that if it gets messy, because again, a court's not going to let an estate roll on unadministered because people can't agree with each other. But yeah, the hat wearing and that duty is sometimes really hard for clients even to separate from themselves, to think, oh, hang on. And particularly like spouses, for instance, where they might have a claim for superannuation and they've been named the executor, they actually have a duty to maximise the estate. So they also have a duty not only to make their own claim for super, but to make one on behalf of the estate, so that the superannuation fund then has to make the decision. And it can get even trickier if you've got self-managed funds of which the spouse remains the main controller ultimately, or has to do something to rejig that to become the main controller. Then a whole lot of other things, can then become tricky there in terms of that conflict of interest.
One of the amazing things about this series that I'm doing is just learning so much about the nuance that's involved. And I kind of came into this thinking, post office wills, if you're really diligent and really clear with how you're doing it and you're following the instructions, it's probably a viable alternative. Clearly, I was an idiot because that's ridiculous.
Look, can I just tell you,
The more discussions I
rules
have,
are what us litigating lawyers just go, oh, like
the
if you
more I
really
think,
want to line
get
the
rid of
pockets of a lawyer after the event, go right ahead. If you want to avoid lining the pockets of a lawyer, please go and see one, and one that knows what they're
Mm,
doing in terms of planning. The difference is enormous. And you're
yeah.
better off
Just little things.
well, it's just little things that are huge things.
Mm,
They're
mm.
really not
Yeah, so
huge
I
things.
think
Yeah.
we had Kelly Gatehouse, I think,
Mm.
and we are talking about administering an estate, and I think she mentioned that in one of the wills they had named all of my offspring or all of my children, compared to, as you said, like naming them individually. And it turns out this particular person had other children that his other family didn't
Oh,
know
yeah.
about, and that gets dragged into it.
Happens.
And that is something that I don't know, I would never think of. And yeah, it's just you speak to a specialist. That's been the definite takeaway of
Yes,
all these episodes: is get specialist advice
please.
because it's particularly with any of the complexity that you sort of covered off there. But let's hop into some of the mechanics. Firstly, to check with disputing an estate, is that under a federal jurisdiction, or is each state a little bit different?
So in Australia, we don't have uniform succession laws. So every single state has a different set of succession laws. So you absolutely have to be speaking to a lawyer that practices in your jurisdiction, and because they will have different timelines, they'll have different people who are eligible applicants to make claims for further provision. And you've got different timeframes within which you need to either give notice of making a claim or actually filing a
And
claim. So,
you've definitely preempted my next
oh,
question there
sorry.
around the timelines of
Yeah.
things. Yeah, no, just because it is so different. I know a little bit about the Victorian one, but in Queensland, for instance, what's the timeline? Okay, the deceased passes away, and let's say probate's granted shortly after. What's the timeline if I want to lodge a dispute?
So it actually in Queensland has nothing to do with when probate issues. You have 6 months from the date
Ah,
of death to give a notice of your intention to make a claim. And if you don't do that, that doesn't have to be anything formal. That can just be a letter written to the executor or their solicitor simply saying, I'm intending to make a claim. You must do that. Otherwise, the executor is at liberty to distribute the estate the day after the 6 month date passes. And once the estate's distributed, there's no estate to claim against. So you must give your notice before the 6 months. Then you must file a proceeding within 9 months of the date of death. Depending on the jurisdiction and the sum involved, it might be a district court or a Supreme Court proceeding. So that's the process in Queensland. In New South Wales, you have 12 months from the date of death to file a proceeding. In WA, I think again it is connected to the probate issuing, and there they have a filing of a proceeding and a very different approach over there. They have registrar-led early stage mediations being run, but they have a far smaller volume of cases to manage there. And I think in Victoria, you also have it's a connection to your probate date. Um, yeah,
mm.
so that just like I said, and I can't speak for all of the other territories. I got to say, but as I'm saying, like it's really important to see a lawyer working in your state because will
Mm.
actually affect how these matters are run. Yeah, for sure.
And in my mind, when you think of an estate dispute, I think of the absolutely worst possible scenario where there is estrangement, there's aggression, there's anger, there's a whole brew of toxic emotion that's going on, and people aren't talking, families dissolve and get ripped apart over years of court time and all that sort of thing. Is that, in your experience, the most common reality when it comes to these kind of things?
Sadly, if people take that normal litigation route, yes. I
Yeah,
mean, that
okay.
is because ordinarily what happens, even if you have lawyers acting as resolutionists in the litigation framework, you will often find that simply unwittingly the process itself positions people. So often affidavits are required to be filed in court, which means people have to swear to the history of the relationship, their own financial circumstances, the financial circumstances of the others if they know, what they know of the estate's, situation, and that in itself triggers a response and then a counter response. And sadly, those affidavits can become quite emotive and not nice to read. And
Mm,
And the other thing people need to remember is that these documents can actually be publicly searched. So if a court reporter decides that your deceased person is some sort of interesting character, or and that's why we hear about the just the stuff that's being filed in our court systems for celebrities, because you can actually read it all. It's all there in black and
mm,
white. And people can find out about it and find their stuff being splashed around on a newspaper, which is a hideous experience. Um, and then, even if we get to the mediation stage, the mediations that we see being run in the litigation framework are late stage ordinarily, except for in WA. Like I said, they have an earlier mediation process, which I think is a massive difference, to be frank. The
mm,
earlier we
yeah.
can get people to and facilitate a conversation around even the understanding of the reality of how much this is going to cost, not just financially, but emotionally, and
Mm.
understand how long it's going to go for and how awful it's going to be. Like, I mean, I just don't think we get that across to people. I think, people think it's going to be we pay a lawyer, get the pit bull, let them box it out, and it's all going to be happy days. It just never is. Um,
Is there a thing? There's a big thing in family law. Often, one of the parties, at least, will want their day in court where they can
yeah,
express and air all their grievances. Basically, is that a thing on the estates piece as
I
well?
think so, but I think more, even lawyers, well, most lawyers, there are definitely those who are litigators, and there are definitely matters that need to be litigated. Can I also just say that?
Mm,
So I'm not having a dig at the litigators at all. But there are matters where people, I think, get a sense that this mediation event, that's the late stage mediation, which is sort of you've got to do it before you can go and actually file your trial stuff. That is the day in to have the stuff, but it's a day long event that often starts
mm,
10 o'clock in the morning, and I've had them go till 11 o'clock at night, and it is, again,
mm,
everyone by the end of it is exhausted. No one's making really good decisions about their future. It's a horse trade.
mm.
And it comes down to money and timing of that, and it's just got nothing to do with actually finding a good resolution for everybody. It's just about stopping the cost bleed and getting it done. You know,
Finding a mutually painful,
yeah,
acceptable
yeah, yeah.
outcome.
And essentially, we say that to our clients, don't we? We say
Mm.
it's a good settlement if everyone walks away feeling like they have compromised. Wow. I've said it to my own clients, and when you get into that, when you
Yeah,
get there, it's that, what can I live with? What am I prepared to walk away just to stop the pain?
you mentioned a motive before around affidavits, and it's funny. It's not the right word, but this is essentially it's an emotional tap. It's an emotional process, but within a deliberately dispassionate structure.
And
Because the emotion, nobody's served by the emotion, are they? Nobody. You don't get more money if you're more emotive and more
And
angry.
you've got to remember, this is at the worst possible time in everyone's life because they've
Mm,
just lost a loved one. And the grief piece and the grief overlay is
mm,
just, it's harrowing to watch as a lawyer, to watch
mm,
clients go through it. I had a client just last week. We finished a matter. It had taken a very, very long time. It was a very complex matter and difficult estate dispute. And she said when they finally got the distribution, and she was ringing to say thank you, we wouldn't have gotten there. She just said, I have to say though, had this guttural, like when the money came in, she just said she just balled up on her bed in the fetal position and cried for about 3 hours. And she said, I don't think I've even begun to properly grieve.
it does seem like sometimes, not to belittle it, but sometimes the disputes process for some people is a way of delaying that grief,
It,
of delaying the
it
acceptance.
genuinely can be. And I mean, in the book that I've wrote, I actually deal with that as a post settlement chapter because I've seen it so many times. And then we talk about mediation in that late stage mediation. We talk about um, settlement remorse, where people come in the next day, in the light of the next day, and they've gone home and they've spoken to their people, and they're like, how on earth did you settle for that? They have that sort of whole settlement remorse of, what did I just do? What just happened?
Mm,
That's awful. and we deal with that often in that traditional context. But even and when that happens, even when the settlement finally does come through, people do. They're so focused on the conflict and the management of the next step and the next step that they just sometimes don't grieve. But some people do grieve, and that's the other thing I've learned in this space. Everyone does
Mm.
it completely differently.
There's no wrong way.
There's
Well,
no, and some people are so much in grief, and particularly you just mentioned spouses. I mean, if you've lost your spouse, that's not something you can compartmentalize because you're looking at an empty pillow next to you every single day.
mm,
uh,
mm,
you had imagined an entire life in front of you that has been completely ripped away. You've got no guideposts. You
mm.
don't even know how you want to live your life forward. How can you possibly make enormous decisions about your own future when you've had no chance to?
And you talked about family members and children having their own financial concerns and their own worries. Someone who's lost their spouse that perhaps wasn't in control of the money or didn't manage the money, they have those exact same concerns. But as you say, it's arguably more persistent because it's every minute of every day is sitting there. And now they're having to fight over it and they're having to defend the decisions that their spouse
Yeah,
had or made.
it is the. I would not wish this on my worst enemy. I genuinely wouldn't. I think this is got to be the most inhumane thing. And then to
Mm,
fight, put them into a court situation, put people into that when all of that's going on. And I think that's probably in part people come to lawyers and go, I just want to hand it over to you. I don't have the energy for it. Please just take it
mm,
from me. Um, and and obviously that's a legitimate approach if that's what you need.
mm,
But again, there'll come a time where over the grieving period you'll be like, well, hang on, this is my life, and that's why I often
mm,
say to my own clients is like, I want to be that for you and I want to be the shield and I want to help you navigate through this process. But I also recognize that this actually is your life and your life to live forward. And it's more important for my clients, I think, to have the proper scaffolding, whether it be by getting counseling and really good financial advice and help empower people to get that financial literacy. Um, just take a minute and a beat to try and work out what it is that you now value, because values
mm.
really shift after someone close to you dies. Some people I see really hang on to everything that they had with the deceased, and that becomes a
Yeah.
natural thing. And sometimes then over time, that becomes less of a thing because you go, I actually don't need this four-bedroom house with all the acreage and everything else. And there's too many memories and I can't be here
Mm,
anymore. But that takes time because grief takes time, and some people are like, okay, screw this. Life's too short. I need to travel. I don't
mm,
want to penny pinch no more. I want to do all the things that I didn't get to do. So it's
mm.
just no one does it the same.
It's so complicated and so variable. And,
Yeah,
some of the more challenging scenarios I've had are where they wanted to honor the legacy of the person that's gone. And then over time, they realized that maybe they weren't doing a great job of managing the money. Maybe things aren't the way they should have
yeah,
been. And that's a really difficult dissonance as well to kind of resolve through that because they love and respect them, but they were human and they've made mistakes. And now we need to try to look at what that means for them within that new context.
100%. Yeah.
I want to pivot. You mentioned there around having that broader team around it, but just before we do, how much harder is it if there's no will? It is a matter of intestacy, and I want to bring a dispute to the estate. How does that
So
play out? Because how does the administrator then know what to do?
harder in a way of knowing what the deceased wanted is it's obvious that you've got no inkling apart from unless they kept saying what they wanted and they never got around to putting it in writing. There is a framework, as I said, in every single state. They will have a intestacy schedule to the Succession Act, which essentially says if there is no will, this is what will happen. And there'll be a scenario around whether there is or isn't a spouse, whether there is or isn't several spouses, because that can happen. You can have a person who's separated from their wife who hasn't had a divorce yet, who then commences a new de facto relationship, and there's never been a divorce. So you actually have two spouses. Or you've got the mistress situation that can pop up as well. But there can be just that
Mm,
happen. That's normal. And then usually it then goes down the sort of um, line of children and other remoter descendants, and then if there are none of those, goes back up to the parents and sideways to the siblings and uncles and aunts and cousins and things. But like I said, sometimes if you've got no one, and you've got and some random aunt from your father's side that you've never known is going to be the person that gets everything, when there are others who have been around you and looked after you, that may not be what people wanted. So the challenge to all of the same things, obviously you can't challenge the validity of the Succession Act, but you can still make a claim for further provision. That's for sure. And you can still look at those other things in terms of any other informal documents or informal wishes, because that's another whole thing I haven't even mentioned. But informal, that's the other tricky thing that we've now got. Most states will have an informal wills or informal testamentary wishes type of section in the Succession Act, which means suicide notes can be potentially taken into
mm,
account. People writing wills up on their computers, leaving
mm,
texts on their phones, even unsent ones have been held to be testamentary wishes. Verbal, repeated statements or an understanding by everybody that there was a verbal agreement that something would happen. And we see these things happen in, that mutual wills sort of space where people are, but there was always this promise that this is what was going to happen, and sometimes people don't document those things. So
mm,
it's just a bigger than Ben Hur area of law, and it's very
mm.
complex. So, yeah, I mean, post-it notes can sometimes be. There was a case I think that was based like a TV show case that was based on that, where people had some left post-it notes all over the place, and one of them had dropped off some ridiculously expensive artwork, and everyone was like, "Which one? What does this belong to?"
I mean, this speaks again to the idea that if you want to leave the decisions in the hands of the courts, the lawyers, and other people, then don't have a will. But if you'd like to take responsibility and control of your final wishes, then get a will in
Yes,
place and make sure that's arranged.
and people often
Well,
quip, don't they? But I'll be dead and it won't matter. But
yeah,
truly,
yeah.
you were saying, about people and a legacy piece around, getting annoyed with the deceased. Can I tell you, a really quick way of getting over some grief is getting annoyed at the deceased, because you won't be remembered well, you know, and
Hmm.
truly, it is just an awful thing that you are doing to your family by simply saying, "Oh, they can work it out when I'm gone." Just like, I was going to say man up, but pull your big boy and big girl undies, get it done, because it's so important, and it's not fair.
Yeah.
It's not fair to leave it, leave the mess behind for someone else to have to clean up, because it's a terrible thing that you're doing to your family.
So talking about the mess, let's move on to the collaborative process, which I think is a much more human way to explore this kind of thing. So can you kind of briefly or just unpack, because I think there's a lot there because it is very different. Unpack for us, what is the collaborative process when it comes to resolving estate
Yeah.
disputes?
Oh gosh. Okay. Now you're going to have to give me one of these ones if I talk too much. Um, so, look, the collaborative process is essentially an early stage. So, no court processes are commenced, save for anything that needs to be done in a consent way to preserve a statutory limitation period, which was the periods I talked about, the 9 month, the 12 month, those sorts of things. So you're staying out of court. It's a staged, so broken into smaller meetings over a period of time, because unlike the day long mediation, we want to try and break it down so everyone's able to take it piece by piece. A staged interdisciplinary facilitation or mediation, if you're more familiar with that word. Interdisciplinary because we have lawyers, but collaboratively trained lawyers who aren't going to amp up the conflict. They're trained to help the family get creative with how they're going to resolve the dispute, and they will do everything in their power to help everyone in the family reach a mutually acceptable resolution. There are financial advisors, and I say yes with a plural potentially because you may need more than one. And it depends on the parties and the type of advisor because you may need to have an accountant and you may need to have a financial planning type of person who can help, look at things and project things forward. And again, collaboratively trained, these people are. And then the last person, which normally is one, but sometimes if they're an enormous blended family, we might have two of them, is what we call a communications coach. That person is normally a psychologist, social scientist, mediator, qualified person, but can also be an expert barrister, mediator type person. But their role really is to help everyone work within those communication dynamics, the family, as well as the professional team. So, what's really unique about the process is that instead of writing these letters that are positional and, try and put your case as far apart as you can to then try and, meet in the middle somewhere or try and, bombard each other's, case so that you can put holes in each other's case. That's not what this is about. We're instead working together to try and find out what's important to each of the family members, um, what their value set is, what their genuine needs are, what their financial circumstances are, and to then try and find a way that we can come to a solution that might be more creative than any court would order, more creative than anything you might come up with in a mediation in a traditional sense. Because the other thing that this process focuses on is maintaining relationship. So if you've got a family that wants to stay together and doesn't want to break apart through this process, it's maintaining relationship. And when you maintain relationship, you can do more creative things in settlements because you can expand out how you're talking about assets, the holiday home, the family beach house. You can work ways around keeping those things. You can work ways around how you're going to accommodate a second spouse into an old age home facility, and to give independence there, at the same
Mm.
time as, working around so that adult children aren't, landlords and tenants to the spouse that's been left right to reside in her own home. Thanks very much. You've got the ability to you be really much more creative, and so the team works together, and we work so that we've got meetings as a team in between the meetings with the family, and the meetings with the family are around a table, not in a room shuttling in between, not speaking to each other. We're actually holding the conversations, and they're difficult conversations, but the the magic in the process is that the conversations are had in a really well supported, constructive way so that everyone understands, and they can be difficult and they can be emotional, but it stops that being the driver to escalate the conflict and allows people to be heard and understood. And actually, it helps people to realize that there's more to this dynamic and more.
And I think sometimes, from what I've witnessed, again, primarily through the family law side, often those intra-family conversations are being had for the first time. Like people, I mean, I'll say it bluntly, but people don't get to this point if they've got healthy communication within their family.
Yeah,
So it's being facilitated in a really kind of supportive environment, but it's often for the first time, so it's quite confronting.
it's quite confronting. And I think even families who have good communications and good relationships can still find themselves faced with a potential conflict and not know how to handle that. Because
Mm.
families, I mean, some families are get quite good at facing conflict because they've had to do it, and some cultures, are really good at, like the Italians, like they just, and
Mm.
everyone's out and it's all out in the open and it's done. Whereas there are other cultures that won't speak about it, and so I think it does depend, and I think conflict, and again, don't forget that grief overlay in our context, that grief overlay and the depression that can happen to some people, just people shut down and they're not able to. And that's the other part of this process. It's brilliant. So you don't have the timelines forced upon you. If people need space, if people need more information, if people need, the time to think about options, you've got all of that. And you do this at a pace that suits everybody. And probably, I should say, the person that needs the pace the most. Yeah.
Which can be frustrating for the person, the steam train, who just wants to keep rolling
Yeah.
on. But by letting the other person have the time they need, I think one of the common criticisms of any sort of dispute process is people never feel heard, which I think ties back to that idea of the day in court. They just want to feel heard.
Yeah.
And this process accommodates that and lets them have that. You've mentioned something a few times I want to explore if we can. Positions, being positional, having positions in your
Yeah.
statements. How does that differ? Like, what does that really translate into?
So when I say the word positions, I mean, your it's the typical litigation. What am I entitled to? And I'm going to say what I'm entitled to. So I'm sticking the flag in the sand over here. And I'm often, as a lawyer, if I'm asked to do that, I then buffer it out, if you like, to make it my position sound even stronger, even though I know that might not be the strongest argument, but I'll argue it anyway because I need to build a buffer within which to negotiate for my client, which is really stupid if you think about it. Like, clients come into us with a problem they think is this big. We say, oh, well, it's actually this big. Let me make it bigger because I know all the things. And then I'm going to add a little bit more to that position just because I know what's going to happen to you. You're going to get squeezed. And then we put them into mediations late stage and we squeeze them back down to here. And then we wonder why clients get frustrated with the lawyers. Because we've just,
because they end up accepting their initial
if we
requirement.
had started here and actually spoken about all of the different heres, we might have actually been able to find something that worked well for people without putting the positions on and saying, I'm entitled. And that's the trouble with the law, is that the cases and everything, and remembering how cases are decided. Like, if you think of a funnel of 95% of the matters, you're looking at 5% of matters that go to court, like 5%. So you are looking through a lens and saying to people, well, this stuff here that you're telling me is relevant at law because I'm looking at the legal problem through my 5% of cases framework. And everything else that's outside the funnel that's really important to you, dear human, sorry, it's not relevant at law, so it doesn't matter.
Yeah.
I mean, it's the most dehumanizing thing. And so why should we put 95% of families who have the potential of resolving this for themselves with good support and well done, you know what I mean? Like, they've all got the opportunity to resolve this for themselves. And we find that they do resolve it for themselves, even in the litigation mediation situation. It's just that they get unhappy. They've spent a shit ton of money, excuse the French, but they've spent so much money getting there. They're emotionally drained and then they end up unhappy. Whereas if we can bring all of that to the front end and allow lawyers to be positive problem solvers and actually help people solve their own issue, as well as supported with financial advisors and communications coaches, as you say, people are heard, people are understood. The positions don't matter because everyone gets focused on finding a solution that advantages all or disadvantages none.
I think on the family law piece, I remember early on we were told the traditional approach is that positions and entitlements perspective, a collaborative process is supposed to be about interests and trying to satisfy as many interests as possible. Whereas the entitlements, you can kind of only have the one winner, really.
Yeah.
When you're doing it from a really positional perspective, that's when you've got A versus B, that becomes really destructive. If you can have A and B working together to satisfy each other's interests.
We're talking about, and it's the difference again between trying to divide up the pie into percentages according to the law, when we could do the divide up the orange thing. And I don't know if you've ever used that analogy, but the interest-based negotiation, that's based on William Urey's Getting to Yes book, where he uses this orange analogy, where if you have someone who needs the peel versus someone who needs the pits versus someone who needs the flesh of the orange itself. You can, it's a different way of negotiating. You don't have to slam a knife down the middle of the orange and cut it into segments and hand that out.
You're recognizing that people have different needs and different.
And sometimes everyone needs a bit of the flesh, but it's a way of working around trying to find how it's going to work. And the other thing is expanding it. If you use that orange to bake a cake and make some juice and something else, you've just actually expanded the orange.
That's a great, I like that
Right.
analogy. That's a really good one.
You've just made it into something else that people can then, view differently. So,
And so I think for people listening that are maybe a bit curious around the collaborative process, because it does sound very different, and we're kind of talking almost in the abstract at the moment, because we can't really get into the specifics around client matters and things like that. But can you walk us through the steps of the process? I mean, really, how does somebody find themselves in this process?
Okay. So if anyone listening wants to look at this as an option, they should probably go to one of the collaborative practice websites that exist. So in Victoria, you've got VACP. There's also AACP, which is the Australian Association of Collaborative Professionals. There is a wills and estates page on that site that then provides links to different practitioners in various states. But if you go to your state-based organisation, hopefully, if their website's up to date, or you can email me and I'll tell you where you can go. I'd be happy to be involved that way. But ask your lawyer. When you're speaking to your lawyer, say, hey, there's this thing called collaborative practice. Is that something I can do? Now, if your lawyer isn't trained in collaborative practice, and if you've already started a court process, you may not be able to switch out of that. But you still should be asking the question around, why can't we mediate? Can we mediate sooner? Can we be exchanging offers? What else can we do to make this a better process? But yeah, start there. I find that in wills and estates, the most successful thing to do is actually first and foremost contact a collaborative coach, one of those communications people. If you speak to a lawyer first, which you can, of course, but if you speak to a coach first, that coach will be the one that can do what we do in the process in the wills and estates space is a suitability assessment. So that person will then contact all of your family members. So this is not a lawyer ringing your family members. This is a person who has that psychology, social skills, social work, background mediation facilitator who's collaboratively trained, and you'll have one in every state who can pick up the phone to your family and just explain the process to them and see whether or not they're interested. There are brochures on the websites that explain. There's a planning process one, and there's a contested estates process brochure, which is, again, no lawyer involved. You just can send it to your family that explains the process. So they can get that. They can get a phone call from a coach and to work out if you're suitable. If you're suitable, then that coach will help you find the team to put around your family. So that coach will help pull together a lawyer for the executors, a lawyer for the spouse, if that person's different, a lawyer for the children. And sometimes you can group people together, if they're all the adult children are willing to be and it's suitable. Sometimes you need to separate one or two of them out because, they've actually got the need to make a claim and they may need to have a different advisor. And so you just pull the team together. And once that team is together, we then start the process. And that's signalled by the signing off of everybody on a participation agreement. That contract essentially says, we're not going to court. We're going to do this instead. And why that's important is because if you have that mediation with the potential of going to court option, people will keep mediating tactically with one eye on that courtroom door.
Yeah.
If you draw that line in the sand and say there is no court, we are going to resolve it here, everyone is focused then on helping you resolve it there. If it doesn't resolve, the result is that you have to, all the professional team have to pull out, and you have to lawyer up with the litigating types. And the reason for that is because this process is very without prejudice, and confidential information is shared, etc., etc. But that's the sort of
Mm.
rules around the contract. Um, but as I said, I mean, the ones that I have run, I haven't had one. I mean, it's new, so there's not been many of them, but we've always been able to resolve them. So that's the process. And then the first thing that happens is the professional team will speak to you as your client, as the client, and then they'll speak with each other ahead of the first meeting. And then after that meeting, you'll work out what the next steps are and what the process is going to be, and you'll set all of the dates for all of your other meetings coming up, if you can. And then you'll have a whole bunch of homework to do. Who's going to gather what information? Who's going to help gather with that information? And then you'll do those things in between. The professional team will then check back in, make sure with everyone that everyone's done those things, meet ahead of the meeting, and then you'll have your second meeting. And those meetings, you decide, you prioritize which issues you want to deal with first. And so usually these matters take, in most estate matters, you find it's probably around the 3 meetings. I've actually got one that's probably going to finish in 2 meetings. It's
Yeah,
going
right.
to be amazing, but I think that's also because this family is like so committed to the process, and they've done so much work, in their own heads before coming to doing the process. But yeah, it's normally 3 meetings. Sometimes it needs to be 4, and in complex, big, big, big families, it just needs to be a bit longer because it's harder to have.
Just the logistics.
Yeah, and it's harder to get across a lot of information in just a couple of hours. So
Mm.
sometimes we do the meeting slightly longer and have a break for lunch in between. So, but it's essentially a series of meetings until you resolve it. And then once you
Mm.
resolve it, it's just the same. You get a deed of settlement. Sometimes you have to go and get final orders, which are just consent orders, but none of the litigation happens.
I was wondering about that, about the documentation at the end. So it's done via consent orders, is
It's
it?
consent orders. And yeah, you might need to file an affidavit, but you might just have the executor's affidavit essentially saying, here's what the estate is worth. Because sometimes if you've got a person who is a minor, or a person with a other legal disability, who needs to be, the court needs to sanction or approve the settlement to make sure that it lines up. So you might need to have some sort of information there to give to the court. But it's done completely by consent with everybody. It's not designed to trigger a I'm going to court litigation sort of thing. So there are carve outs in the agreement that you sign that allow you to do those things.
You mentioned that it's a newer process, but it is very, very thorough, very detailed,
Mm,
and a very acceptable form of resolving dispute.
absolutely.
I think being new might result in a bit of pushback when you ask lawyers about it because
Yes,
they may not have the experience
that's
of it.
right. So I've trained over 120 lawyers and financials and coaches nationally. So that's not a lot of people in every state. So, but there's
Mm.
enough people in every state now that should allow you to pull together a team. And these days with Zoom, you can definitely pull people in from other regions, particularly the neutrals like the financials and the coaches. Um,
Yeah.
but with that, yeah, it's you do have to ask about it, and if your lawyer isn't offering it, then you may need to shop around to find a lawyer that is offering it. My dream is to really get more of the profession trained up so that we can offer it openly to everybody. There are a lot of collaboratively trained family lawyers, um,
Mm.
and they've been at it for 20 years. We've probably only been at it for about 5. So
Mm.
it's a newer thing. But don't let that stop you from asking about mediation. There's other forms of doing this stuff earlier. Um, you don't have to go down that massive litigation pathway.
Because it is about resolving the dispute. It's not about winning the
Yeah,
dispute. It's about resolving it, and that in itself is the victory. Because then you get to return to your life
yeah.
and not be stuck in this process for years upon years of uncertainty, and you can't. It's deeply unhealthy. We can't talk about costs specifically, but one question a lot of people will be having is where does this fit in the spectrum of expenses? If we talk about litigation being, that day in court and we're doing that, my perception of that is that's a 6-figure expense
Yeah,
normally, minimum.
yeah.
And that expense is normally borne by frequently the estate, I think.
Sometimes I want to say, because again,
Mm.
everyone has that assumption that it's all going to be paid for by the estate. That's not always the case. So if there are frivolous or claims that don't have a lot of meaning to them or reason for them, you may not recover the cost from the estate. And often what happens when you get to mediations is that people will start negotiating on the basis that you bear your own costs out of whatever
Yep.
settlement it is. So you should never go into those sorts of things thinking, oh, there's a massive estate or even a small estate. It's going to come from there, because it may not, and you may end up
It's not a free roll.
shooting yourself in the foot, taking that approach. So yes, and when you're looking at further provision applications, you're probably looking at at least 30 to 50, even getting it to a mediation per party, to let alone talking about getting it to a trial. Trials can be enormously expensive, like you said.
That's 30 to 50,000
Yeah, each person.
per party.
Yeah. So you add all that up, you are often seeing hundreds and hundreds of thousands of dollars in legal costs before you even to get to a mediation. Yeah. So
And mediation's a lawyer represented normally. You have to have a lawyer in a mediation, or can you self-represent through that?
no, you'll usually have a lawyer, and sometimes you won't just have a lawyer, you'll have a barrister as well. So, because we talk about the day in court stuff, there's opening sessions where people chest beat and, say what their position is and why they're going to win the case and all of that sort of stuff. So that's definitely how it's done. It's done in a very adversarial way. And then you part off into your little rooms, and the mediator has to try and ping pong around until everyone, you know, comes to heel.
And then a collaboration in terms of that kind of cost framework. Is there any chance for a collaboration to be dearer than a litigation?
I would imagine that would be highly unlikely.
Yes.
So I wouldn't say never, but I mean, I don't think I've ever seen one blow out to being like, more expensive. Collaborative matters, and again, depending on how many lawyers and how many parties are involved, and as I said, we can sometimes group people, so you don't have to have a lawyer per person. But you'd probably be looking, if you think about having a 2 or 3 hour meeting and some preparation time and some post meeting time that a professional would need to do, you're probably looking at about, I don't know, $5,000 to $6,000 per meeting series, if you like, so per professional. So they aren't cheap, like you still might end up everybody paying, $40,000, $50,000, but that's everybody.
That's
Yeah,
resolved, and that's
resolved.
everybody.
That's right. So they're not a cheap process, and sometimes it can be more expensive. And particularly if you're having to get expert reports and other things that need to be obtained. Valuations can be quite expensive. They're business
Yeah.
valuations and those sorts of things. So
But all of those things would have to be done via a litigated process.
a lot of those things would also have to be done there, and sometimes
And probably a competing expert
yeah,
report.
I was about to say you'll have one expert and then another expert, and then and
The
they
expert
don't
of experts.
agree. Yeah, so this is a process where you all agree on how it's going to happen, and you don't get forced into having a valuation done. You don't want it, don't need it. You're planning to sell the house anyway. The market will tell you what it's worth. Do you know what I mean? Like you don't have to incur those costs if everyone agrees that it's probably worth around this much or whatever it might be. You don't have to. So you're fully in control of all of that. And as I said, you get to everyone, and it's a level playing field. That's the other thing, is no cards to the chest. There's no tactical information being withheld. It's an open book. Everybody puts the cards on the table, and then we try to work out how to make it work and whether we.
Yeah, so it may not necessarily be heaps cheaper, but for the right people, it's going to be heaps better.
Oh yeah,
I
and
mean, even talking about
the
it,
value you get in each of those meetings is the other thing that I want to speak about in terms of that, because you have everybody's lawyer in the same room. You've got the financial advisors there, so you can get on the spot tax advice. You've got a communications coach helping you work through the emotive stuff and get people to cut through what really is going on and get the conversations to the nub of the matter so that people can, be heard, understood, and move forward. You get that done in 2 or 3 hours, what you would could take weeks and months if you were ping-ponging between experts. Oh, wait a minute, I have to go get tax advice. Off I go get tax advice. Then I come back.
Mm,
The value you get, because everyone's so prepared for each meeting, and in terms of then achieving the next step, is enormous. So it can be settled far faster, if faster is what you want. I mean, it can take,
mm,
6 months, 12 months, your pace, but it doesn't take 2 years, 3 years.
mm. And I think that idea of the expense or the time or the involvement, the the cheapest, easiest, fastest way to do it is to do it yourself and not involve anybody else. But the reality is you can't do that. So you're having to bring in experts, and then you're choosing your path of expertise you want to head down, and keeping in mind how do you want it to be at the end. Do you not Are you okay if the family is torn apart, if it means that your positions are fully prosecuted? Okay, a litigation process. As you say, it's completely valid. Some cases just have to go down that
Yep.
pathway. But if you're looking for a different experience for you, for your family, for their legacy, all of that, a collaborative process, I think, can be quite attractive, but it is very different. And it's not a penny pinching object. You're choosing it because the value represents what you want for you and your
It's a
family.
bespoke process that will align with your value set and your family value set. And it will give you a solution that you have crafted that has longevity into your future life.
You mentioned earlier that going through the court process, your affidavits and your declarations can be public record. What about through a collaboration? Is there greater privacy?
100%. It's all confidential. And
Mm,
not much is written down, save for, letters of advice that might need to be given lawyers to their clients. But again, they're not given to position anybody. They're done really to, I mean, we've still got our professional obligations to make sure that, people have understood the advice given them, because sometimes in the settlements, it might be something that we would be saying, oh, if I was fighting this in a litigation matter, I'd be telling you, you're giving away too much, but too much, but they're not really giving away too much because their family relationship and the ongoing relationship means more to them. You know what I mean? Like
mm,
it's that kind of thing. Or the financials will show that it's enough, for them. So
mm,
whatever the enough is for that person. So it's we do have to do that, but really none of that there's no affidavits filed or served unless, as I said, they're needed to achieve a consent final order. And sometimes
mm,
final orders are done for tax reasons, so that we can get access to the capital gains tax savings that come out of resolving a family provision application with a court
mm.
order. So again, they're just things that are done so that we get the best for the family, and or to give the executors some comfort around that. So it's just you don't have any of that publicly available. And when it's done for a court approved process at the end, those affidavits are sealed by the
Mm.
court.
Yeah.
Yeah,
So far more private, far
far more
more
private.
individual, far more
And
bespoke.
really, really vanilla. If they have to be filed as an open affidavit, it's vanilla, as in it
Mm.
just sets out the facts. There's none of the, yeah, argy
Emotion and
bargy.
none of the dirty
Yeah,
laundry
yeah, that's
isn't
right. No
aired.
dirty laundry.
I am conscious of sort of your time and our time, so we'll start wrapping up shortly. But I do have one big question, I guess. Who is a collaborative process really good for? We've kind of touched on it, but who should be really thinking about heading down a collaborative pathway?
Look, I think families that do value just, keeping the peace, and
Mm,
being able to continue as a generational family, being able to have those Christmas dinners and other things going forward. But it's not just, those sort of close knit families that it suits. You know, one of the collaborations that I ran involved, you use the word estrangement. Some people don't understand what estrangement is, but estrangement is just where you've had a break in the family, and sometimes those estrangements are caused by the deceased. People have been
mm,
estranged because, there's been a sexual, problem between, that's been a sexual assault, or they're estranged because someone's, gay, and that the
Mm.
parent hasn't accepted that. So I have seen families be able to reunite once the deceased has passed, because the relationships can be restored when there's an understanding around what caused the estrangement.
Whereas if it was an argy-bargy process, that could possibly deepen the divide
Absolutely.
or worsen the situation.
Absolutely. And it can be really highly sensitive, awful stuff to have to put in affidavits, and file them. So there's definitely that. And I think, and the one thing that this process does is give your family the very best chance of actually improving their relationships.
Mm.
Because you are so scaffolded, you'll be taught how to have a difficult conversation, and how to manage that well, and to stop and listen and feel like you're hearing each other. And you know what I mean? Like you'll actually learn how to do it, so that the next time something comes up, you'll be able to do it without the involvement of other people, or know where to turn if you need assistance to get a third party involved. And I think that's the healthy part about this, is we're never taught that. Like, you don't go to
No, never.
school for families on how to deal with conflict. Like, no one teaches you that.
Yeah. You inherit your family's approach to it. If your family's approach isn't that open, healthy method,
That's it. You've got the
you can be stuck in it.
you've got those that stick their head in the sand, or those that bury it and internalize it. Those that shrug their shoulders and say it's all never going to change anyway. It's always this way.
People pleasing.
Yeah, it's there's so much that can happen, and I've seen, and as much as I've seen emotion in the room, um, every time I've seen it, it's just broken the the barriers in the
Mm.
family, and it reestablishes a new way of the family communicating. And so I would also say, even if you've got a blended family, one of my most successful collaborations was a second spouse with adult children. And the collaboration we're onboarding right now is a second spouse with adult children. So just because it's a blended family doesn't mean this doesn't
Mm.
suit. So the other commonality that can sometimes be enough is people just deciding that they don't want to line the lawyer's pockets with money.
Yeah.
They don't want to waste someone's hard-earned inheritance, dragging it out through the court and fighting. But you have to be really committed. This is an open process. This is not a tactical process. So you still have to have a bit of trust between each other. And you have to be willing to be open in your communications with each other. You have to be willing to leave the past behind and look forward to a future. So if everybody can do those things, you've got the potential, with support, to do the collaborative process. And sometimes when there's the greatest dysfunction, it's kind of the most important time to have the collaborative process. If you've got people who are suffering with drug dependence, alcoholism, mental health issues, the court process is incredibly taxing.
Mm.
So being
Mm.
able to have that with the additional scaffolding and support is enormously bespoke and helpful and kind, and far more gentle on the humans. So
I think that's a really important point, that you can be arguing with somebody in your family, but still love them and not want them to go through that
yeah,
process. And to have something that you can offer that is kinder, it is gentler on people. It's not as rocky as it can
yeah.
be going the other way.
And it doesn't
It's
mean
good to have
it
that as an
doesn't mean
option.
you're all holding hands and singing kumbaya. Like, that is
Mm.
not what this is. This is an opportunity to be heard, but it's just an opportunity to be heard early,
Mm.
constructively, and allow still to help everyone to move forward to finding a solution that works for everybody. So, yeah.
I think it's really important. And I think, Zinta, I want to thank you for joining this podcast, because I think it's so important to me to show people there's this alternative out there that doesn't have to leave their family destroyed in a burning ruin of relationships. Like, you can find a way through it all. It's about resolving that dispute, not winning it. We will wrap it up there, but before we do, where can people reach you if they have any questions or they wanted to run through some things?
Yeah, well, I've got my website, resolveestatelaw.com.au. You can absolutely reach out there. But you'll probably find me on the socials, on LinkedIn, Instagram, even Facebook. You can reach out anyway, and I'm more than happy. As I said, although I'm a Queensland lawyer and I cannot do collaborations in other states, I can hook you up with other people who can. So I'm happy to be
Yeah,
that conduit
fantastic.
if you need.
You also mentioned a book you've written. What's the
Ah,
name of the book?
here I have one that I prepared earlier. I have one sitting behind me all the time. Called Rest in Peace: How to Manage an Estate Dispute Without Inheriting Heartache. And I wrote this. This is not a legal text. This is a book for normal people. Not lawyers.
You said it's
I
into
know, I
not
know,
not
I
me.
did. But it is genuinely designed to step people through the process, the alternatives, all of the alternatives, including those kitchen table negotiations,
Mm,
the difference between lawyer-led, um, settlement stuff, collaboration, litigation. It's all in there. There's also a good few chapters at the start that talk about grief and how to help you navigate that process when you're in a court process. And at the back, there's also some stuff around values and checklists and other things, just so that you can really stay focused on what's important to you. Because even though I run litigation stuff, I still scaffold my clients the same way. I often say your
mm,
experience with me is going to be the same. The other side's experience of me will be very different. Why some lawyers
mm.
kind of go, "Oh, I thought you were collaborative," and I'm like, "What do you think that meant?" Because unless there's a contract in play, it's game on. No.
Doesn't mean pushover.
Well, like I said, recovering litigator. I mean, you can't always get the litigator out, but no, I mean, if I have to fight, I will. I have to. It's my job.
Mm,
I don't
mm,
like
mm,
to, but I will.
mm.
But yeah, it's just hopefully a good resource for anyone. So again, through my website, you can get a hold of that book. There's an e version copy, or if you order a hard copy, we send it with nice packaging and some tea and some nice essential oils and a candle or something. I don't know. It all comes in a little pack.
I think the values piece at the back, like we've sort of skimmed over that side of it, but the process of exploring your interests and your priorities through the process is rooted in your values and your future desires. So I think that's a really important factor to consider and work through with people. Um, Zinta, thank you again. This has been fantastic. I'm a big supporter of the collaborative process on the family law side. Wasn't super familiar with it on this side. It just makes a lot of sense. And I think for the right people, like we've
Yeah,
said, it makes a lot of sense. So thank you
you're
again.
welcome.
We'll call it there. Um, this has been another episode of Life, Loss and Legacy from Planning Solo. If you have any questions at all, we'll have Zinta's details in the show notes, but also you can contact me, Jordan, at planningsolo.com.au. And until next time, we'll see you then. Thanks a lot.